Welcome. Today's video covers reasonable suspicion, profanity as free speech, and solicitation, and comes from DM Register's channel. A link to the original video can be found in the description below. On October 29, 2018, West Des Moines, Iowa police received a call of a suspicious black man wearing a hood and jacket in the middle of the day, which was around 70 degrees Fahrenheit. The man, known as Kalon Hill, was handing out flyers for Representative David Young's congressional campaign. Officer Ray approached him and began investigating.
Someone called in about you. Are you just handing out flyers?
What am I doing wrong?
I didn't know. People were concerned.
Yeah, concerned for what?
Their neighborhoods.
Hold on 1 second. Hold on 1 second, Ricky.
So it's not a big deal.
Yeah, no, I'm just trying to figure out what we were concerned about.
Well, in West Des Moines, we have a soliciting ordinance, so if you're knocking on people's doors...
Yeah, soliciting is what? Offering services.
Yeah.
I'm not offering a service.
Okay.
Okay, so with that being said, I'd like you to leave me alone, sir. I've not broken any laws.
Well, I'm still doing an investigation, because if you're recording me, I'm still recording too, so it's okay.
Investigating what, sir?
A suspicious person, they called in about you.
Okay.
The officer claims that he has the right to detain and investigate Mr. Hill because someone called him in as a suspicious person. In the case of Terry versus Ohio, the Supreme Court ruled that a law enforcement officer may conduct a brief investigatory detainment if the officer has reasonable suspicion to believe the person stopped has violated the law. This means there must be enough facts to convey to an objectively reasonable person under the totality of the circumstances that the suspect has broken the law. While a call can constitute reasonable suspicion under the right circumstances, vague generalizations about a person cannot. In the 2005 case of United States v. Maltais, the United States Court of Appeals for the Eighth Circuit, which has jurisdiction over Iowa, said, general assertions of suspicion are not sufficient to justify detention. Similarly, in the 2020 case of Chestnut v. Wallace, the court said, a vague, conclusory statement that a person is suspicious is insufficiently specific to support his detention by the police, and that this was clearly established long before the incident in this video. Therefore, the officer's claim that a mere call of a suspicious person gives him the right to conduct a detainment is incorrect.
You have an ID with you?
No, I don't.
Do you have your name? Have your name?
No. Am I under arrest?
No.
Okay.
Well, I'm investigating.
If I'm not under arrest, then you have no reason to be talking to me, right?
I can. Actually, yes. You're a suspicious person. Someone called in about...
Suspicious how?
A neighbor called over here, so I don't understand why you're being difficult about this.
I'm not being difficult about anything, because I haven't done anything out of the way.
Okay.
So with that being said, I'll go about my business.
Okay, I'm not done with you yet. You're not free to go.
Have I done it? Have I broken any laws?
4255. Can you send me one this way, please? He's uncooperative.
Have I broken any laws, sir?
Here, Mr. Hill attempts to evade the officer when the officer tries to detain him. While it seems unlikely that the vague call and Mr. Hill's evasive behavior under these circumstances would constitute reasonable suspicion, it is important to note that evasive behavior is a big factor in determining if reasonable suspicion exists. In the case of Illinois versus Wardlow, the United States Supreme Court said, nervous, evasive behavior is a pertinent factor in determining reasonable suspicion. Therefore, it is always best to ask if you are being detained or not before attempting to leave the scene.
I'm talking to you. I'm not done. I'm investigating a suspicious person.
You have a nice day, sir.
Stop. Stop now.
For what?
I can detain you. Stop.
For what?
Because you're not listening. I'm investigating a suspicious person. Stop
sir,
now.
Sir, have I broken any laws?
Stop.
Tell me what laws I've broken.
I told you to stop.
I don't have to stop.
Yes.
No, I don't. Either arrest me, tell me what laws I've broken,
Can you
step
it up? He's being uncooperative and trying to walk away from me. He won't identify himself as a suspicious person. I'm investigating.
I'm going to ask you one more time.
I'm going to tell you to stop.
For what?
Because I'm talking to you and you're...
What have I done that's wrong?
I just told you I'm investigating who you are.
You're harassing me.
5700 block of Aspen. Stop. I'm telling you to stop, and I'm not going to tell you again.
And what will you do if I don't stop?
I will detain you.
Detain me for what?
You're not listening. I'm doing an investigation of a suspicious person.
Suspicious person? Have I broken any laws?
That's not the point.
Have I broken any laws?
Someone called you and it's a suspicious person.
Okay, and? You can be a suspicious person. Mr. Ray?
Really?
I feel like you're a suspicious person.
How would I be suspicious?
You look suspicious to me.
Okay, how would that be? I'm in a marked
You're a
police car.
white man. You're suspicious to me.
I'm suspicious to you because I'm a white person?
Yeah, with a gun. You're suspicious to me.
No,
now
stop.
Get away from me. I haven't done anything out of the way. You can't arrest me. Arrest me right now if you want to.
Here, turn around, put your hands back.
For what?
Because you're not. Stop. Turn around.
What have I done wrong?
Because you're not listening to me.
What have I done wrong, sir?
Get the phone out of my face. Because you're not. I'm investigating a suspicious person.
Sir, what have I done wrong? I'm not suspicious. I haven't done anything. I'm walking up the street. I haven't done anything wrong. I don't have any.
Neighbors have called on you.
Sir, I don't care if anyone has called on me. This is not their area.
This is a public roadway, so this means.
Okay. It's a public roadway. That means that I have the right to be on this roadway. Yes or no?
Everybody has a right to be on the public roadway.
So I am not a suspicious
But you don't have a right to be on anybody else's property or curtilage.
I'm not on anybody's property.
Why would someone call it in?
That's their concern.
The officer's sole reason for conducting an investigation is because he believed Mr. Hill was going door to door and handing out flyers, an act which he says violates a municipal solicitation ordinance. However, in the 1943 case of Martin v. City of Struthers, the Supreme Court said, it has been a common practice in this and other countries for persons not specifically invited to go from home to home and knock on doors or ring doorbells to communicate ideas to the occupants or to invite them to political, religious, or other kinds of public meetings. Whether such visiting shall be permitted has in general been deemed to depend upon the will of the individual master of each household, and not upon the determination of the community. The court further reasoned, freedom to distribute information to every citizen wherever he desires to receive it is so clearly vital to the preservation of a free society that, putting aside reasonable police and health regulations of time and manner of distribution, it must be fully preserved. The dangers of distribution can so easily be controlled by traditional legal methods, such as no soliciting signs or locked gates. Additionally, in the 2002 case of Watchtower Bible Tract Society v. Village of Stratton, the Supreme Court struck down a municipal ordinance requiring individuals to obtain a permit to pass out flyers door to door, stating, it is offensive, not only to the values protected by the First Amendment, but to the very notion of a free society, that in the context of everyday public discourse a citizen must first inform the government of her desire to speak to her neighbors and then obtain a permit to do so. A law requiring a permit to engage in such speech constitutes a dramatic departure from our national heritage and constitutional tradition. The court expressly stated that neither protection against fraud or protection against crime were constitutionally sufficient reasons to require such a permit, which the city of West Des Moines stated were their only reasons for enacting their solicitation ordinance. Further, the ordinance only requires a permit when an individual is selling merchandise or services, which clearly was not going on here considering the only items he had with him were campaign flyers. So even if these First Amendment principles didn't apply here, the officer still would have lacked reasonable suspicion to stop Mr. Hill.
So they're concerned.
Hello, listen, I'm recording right now because this police officer just walked up on me saying I'm a suspicious person and he was going to detain me for whatever reason.
Because you're not listening.
Listen, sir, I don't know how y'all do things here, but I'm...
No, where are you from?
Record it, so could you please get off the phone while I'm trying to record? Thank you.
Okay, call your boss.
Sir, listen to me. Listen to me. I work for somebody that will have... Look, listen to me. I work for somebody who will get on... I'm going to ask you one more time.
Okay, actually using obscenities in front of public people is a crime.
Sir.
The officer claims that obscene words are not protected speech and are illegal when uttered around other people. There are several different types of speech that are not considered protected under the First Amendment. These include speech posing a clear and present danger, speech which defames another's character, and, among others, obscene speech as well. In the case of Miller v. California, the Supreme Court established a three-part test in determining whether or not speech is obscene. First, the speech must appeal to the prurient interest of the individual. Second, the speech must depict or describe venereal conduct in a patently offensive manner. And third, the speech must lack serious literary, artistic, political, and scientific value. Speech is only considered obscene if it meets all of these standards. Clearly, the use of a few swear words by itself does not fit all three prongs of this test. Contrary to the officer's assertions, the First Amendment generally does protect the use of swear words. In the case of Cohen v. California, the Supreme Court said, the state may not make the simple public display here involved of this single four-letter expletive a criminal offense. Relying in part on this case, the Eighth Circuit said in the case of Thurairajah v. Fort Smith, criticism of law enforcement officers, even with profanity, is protected speech. Once again, this rule was clearly established long before the incident in this video.
Listen to me. I'm going to tell you one more time.
I don't care who you work for.
You don't care who I work for. The person I work for pays you. So okay, I'm going to tell you one more time to get away from me. Leave me alone.
You're
leave me alone. Get away from me.
Yeah. He's still walking away from me, being uncooperative and refusing to identify himself.
I don't have to do anything. I don't have to identify myself to you. I don't have to do anything. If I have not broken any laws, I don't have to.
Westbound, we were 58th and
So
Aspen.
again, I asked you to leave me alone. If I've not broken a law, you have no reason to detain me. If you had a reason to detain me, you would have detained me already.
I can, actually, yes, I can.
For what?
Because you're not listening to my directions. You're not following. Turn around, right now.
Sir.
Turn around. I'm done.
So you're going to arrest me?
I'm detaining you.
For what? For
Don't
what?
be resistive.
For what? For what?
Because you're not listening to what I'm saying. Do not be resistive towards me.
All right.
Walk back to my car.
All right. You've done
I'm
it.
detained.
You have done it.
Yep.
You're a fool. You are a real fool, sir. I can tell you for sure I have not done anything wrong. I have not broken any laws. So if I suggest you let me out of these handcuffs immediately.
Well,
Sir,
when
could you tell him to take me out of these handcuffs? I have not broken any laws.
Okay, did you stop when he told you to?
No, he kept walking
Okay,
away.
then that's interference, so you're under arrest. Have a seat.
Interfering for what?
Interference, you disobeyed the lawful order.
You were sitting right there and I told you to stop 4 or 5 times to identify yourself because there was a suspicious
Sir.
person car, and I'm investigating that.
Investigating what? I have not done anything.
Okay.
You can't just run up on anyone and just say, hey, you look suspicious.
Okay, he told you to stop. He didn't.
And we had calls on you, like I told you.
You're practicing stop and frisk right now. I've not
No.
done
No, you're
anything
under
wrong.
arrest. So.
Under arrest for what? Under arrest for what? What have I done wrong? Tell me now.
You didn't identify yourself.
Okay.
You didn't stop when we asked you to.
Here, the officers used the man's refusal to stop and identify himself as grounds for his arrest. However, under the Fourth Amendment, police cannot force individuals to identify themselves without a lawful detainment first, and even if they could, Iowa law does not require a pedestrian to identify himself when police detain him. It also does not require a pedestrian to submit to an illegal detainment. After his arrest, Mr. Hill was charged with harassment of a police officer, which, not surprisingly, he was quickly acquitted for. Overall, the West Des Moines officers get an F, for knowing nothing about the law, baselessly making accusations against Mr. Hill, and ultimately arresting him for no reason. The lack of knowledge and unprofessional attitude these officers have shows forth either a total absence of training in just about any constitutionally protected rights or a complete disregard for them. The officers were also cleared of any wrongdoing by their department, which only serves to further the divide between officers and the citizens whose rights they are supposed to uphold. Mr. Hill gets a B-. While he did have a basic understanding of the law, he ultimately engaged in a pointless argument, attempted to evade the officer, and didn't even attempt to remain silent. Had he done better, this encounter may not have resulted in his arrest. I would highly encourage individuals dealing with law enforcement to be calm and cordial rather than agitated and evasive, as that can only be used against them in court.